Welcome back to the Emily Show. We've got to talk about TikTok, which has been playing with the internet's emotions, and break down what the Supreme Court had to say because they ruled on Friday at the very end of the week ahead of the TikTok ban that was supposed to go into effect January 19th and kind of went into effect overnight, January 18th, Saturday. We've got to talk about it. And then, of course, at the end of the week last week, Justin Baldoni's attorneys filed the lawsuit that they had been talking about and assuring the public that was coming, saying that they were going to be suing Blake Lively and Ryan Reynolds. And they did on Thursday, filing a 179-page complaint. So we're going to be talking about the key takeaways from that vis-a-vis all of the saga now of litigation that's ongoing and what that's likely, because in one of the cases, we finally have the very first court date on record for any of the cases, and we're going to talk about that too. There's a lot more going on in the legal news. We're going to have to get to it later this week. Don't worry, replay crew that's on YouTube, everything's timestamped down below, and we've got a few notes for what's coming up this week on the live streams. So let's get into it. I'm legal analyst Emily D. Baker. This is the Quick Bits, where I break down just the main points of the pop culture and entertainment cases I'm currently covering on YouTube and the Emily Show podcast. Let's get into it. First, we will likely, be back in Idaho this week. The court in the Bryan Kohberger case has a day and a half, 2 days set aside for hearings on discovery motions. Well, it seems that there is some tussling going on about how much and what parts of those discovery motions will be public. There is still an ongoing fight about discovery in this case. So much of it at this point has been sealed. It's hard to get a sense for exactly what's going on, except that there's a discovery fight going on in the case. And we know from earlier on in the case, there were issues with how many different agencies were involved in the investigation of those murders in Idaho, and getting that information from those agencies to turn over to the defense seemed to be an ongoing issue for the district attorney's office. So the defense recently filed motions asking that the discovery hearings be public. The court just filed at the end of the week a notice of hearing for January 21st, where the court will have a closed hearing, means no public, just the lawyers, the defendant, the court. But we'll have a closed hearing on January 21st to determine what parts of the discovery hearings, if any of those parts, will be available to the public. I anticipate that that will be some parts publicly available on Thursday, and if so, I will be streaming it live on Thursday on the Emily D. Baker YouTube channel, where we cover court live. So if not, don't worry, there's plenty of other legal topics that we'll be covering, but if those hearings have public aspects to them, I will be covering it. It's hard to follow what's going on when everything is sealed. Speaking of hard to follow what's going on when everything is sealed, for those of you that are in the Law Nerd app and on the Quick Bits channel, you will see that I put up a cut down of some of the streams that I did covering the very early days of the Wendy Williams conservatorship. I covered that back in 2022 before the court made everything on the docket private and sealed. So I had the documents before they became sealed and covered those on the YouTube channel. So some of you have been like, I love the new hair. It's like, no, this is old hair. But I thought that that would be helpful context, since last week we heard from Wendy Williams in an interview with The Breakfast Club. If you want to talk more about what's going on in that conservatorship, please let me know. And there is a lawsuit going on with the conservator that I have not covered yet. Again, if you're interested in that, let me know. So I thought that the context and the documents for that conservatorship would be helpful now that we're seeing Wendy Williams herself speaking out about this in such a public way. If you do not know the backstory of that conservatorship, the video will be linked in this video. Go watch the breakdown. It's really wild, and I wish that that wasn't entirely sealed so we had more transparency in what's going on, and I think that's probably frustrating for everybody. Speaking of transparency being frustrating, TikTok, WTF, watching the internet this weekend has been wild. watching everything go down on Saturday night as the TikTok app went dark, to TikTok coming back in some fashion on Sunday. We are going to go through the Supreme Court ruling and talk about what that means with the law that is still in effect. But with all of the things that have happened, we see the incoming administration, the Trump administration, saying that they're not going to enforce this ban. They're going to issue an executive order and a 90-day stay for the implementation of the law, the implementation being the fines that are associated with it, which are $5,000 like per user per day. So for the Apple App Store or for the servers, you can see with over 170 million Americans how that could be prohibitive for the companies, which is why they made the fines that staggering, so that it would prohibit US companies from supporting the TikTok app. Now, what happened when TikTok went dark ahead of the ban? It seemed that that was a choice from TikTok and ByteDance because it was A, ahead of the deadline, and B, it didn't seem that the servers just went down and everything went dark. There were statements put up by TikTok saying, due to the law in the United States, TikTok is unavailable right now. And then it was like, welcome back. We have been saved on Sunday after messing with everyone's emotions. But I don't know how this is going to roll out given what the provisions of the law are. And for many TikTok users, all of the things we're going to talk about next might not matter because this gets into separation of powers. Government teachers everywhere, anyone who teaches civics, anyone who's having these conversations is going to be living for this real world case example that might be relevant to the students that they are talking to, because we are getting into some nuanced discussions of the powers of Congress, the powers of the executive branch, the powers of the judicial branch. I don't know if we've had as captivating a case study in the separation of powers in the US government in recent history, where you can really break down and look at what is the executive branch vis-a-vis the judicial branch, vis-a-vis the legislature. This law has all of it. So lawyer brain is trying to figure out how some of this stuff will work practically. I'm sure that there are many that are like, I just want my TikTok. I do not care how this works. I am curious to see how some of the executive powers are going to be used vis-a-vis congressional action. Let's look at what the Supreme Court said. Let's look at the mechanisms in the law for TikTok to be able to operate in the US. The question I see a lot is, why did this magically take place like the day before a change in administrations? Well, the law said 270 days from the time that an application that was set out as an application that was identified as an issue under this act. And then from the time that happens, then there's this 270-day window. Well, when Congress passed the bill, the 270-day window started for TikTok only because the law specifically identifies TikTok. And the last day of that 270-day window was January 19th, 2025. So the timing is challenging at best. But there was that 270-day window. No cap cut was not identified. No, it would not have had fines and penalties because it wasn't identified by this law. So that was a choice that was made to take cap cut offline. I do not know if it's back up. As of recording this, I have not seen that TikTok is back in the Apple App Store, Google Play Store. That may change. I also wonder if part of the app being dark for slightly more, it seems, than a 12-hour period was so that servers could be changed so that Cisco, the server company, not the thong song, was not implicated in this, whether there was some server movement so that TikTok could continue to operate. Because remember, the law targets the US-based and owned companies that would support the application, and that's the servers and the app stores. So if you move the servers, then if it's not in the App Store, can it continue to operate on different servers at the moment? It would seem that under the law, the answer is yes, if it's on different servers. How does that address the data privacy concerns, you may ask? I don't know. But it wouldn't be available in the App Store. So anyone who has the app, if the servers are now no longer in the US or with a US-based company, then that US-based company can't be fined for supporting TikTok. So it might be that the servers were moved. Do we know that? No. Has there been any comment from Cisco on that? No. The only comment I saw over the weekend from the company was that they were preparing to shut down the TikTok servers. What functionality will the app have going forward? Unclear. But what we do know is it's going to continue to be a bit of a roller coaster. Let's see what the Supreme Court had to say, shall we? This is a per curiam order from the court. This is a unanimous decision, though there are some concurring opinions that we will look at. I'm going to try to answer some of the questions that we had when we watched this entire hearing together live on YouTube. So if you want to go and watch the arguments to the Supreme Court, A, they are on the Supreme Court website if you just want to watch them without commentary. B, they are on my channel if you want to watch them with my commentary. The court lined out as of January 19th, the Protecting Americans from Foreign Adversary Controlled Applications Act will make it unlawful for companies in the United States to provide services to distribute, maintain, or update the social media platform TikTok unless U.S. operation of the platform is severed from Chinese control. That is the baseline of the act. The Supreme Court goes on to say, we consider whether the act, as applied to petitioners being TikTok Inc. US and a group of creators, violates the First Amendment. In doing so, we are conscious that these cases before us involve new technologies with transformative capabilities. This challenging new context counsels caution on our part. As Justice Frankfurter advised 80 years ago in considering the application of established legal rules to totally new problems raised by the airplane and radio, we should take care not to, quote, embarrass the future. They go on to line out the app saying that TikTok Inc., remember that is the US company that runs TikTok. They say TikTok Inc.'s ultimate parent company is ByteDance Ltd., a privately held company that has operations in China. ByteDance Ltd. owns TikTok's proprietary algorithm, which is developed and maintained in China. The company is also responsible for developing portions of the source code that runs the TikTok platform. ByteDance Ltd. is subject to Chinese laws that require it to, quote, assist or cooperate with the Chinese government's intelligence work and ensures that the Chinese government has, quote, the power to access and control private data the company holds. They then go on to line out the history of where these conversations began, stating in August 2020, President Trump issued an executive order finding that, quote, the spread in the United States of mobile applications developed and owned by companies in China continues to threaten the national security, foreign policy, and economy of the United States. And then they list the executive order. They go on to talk about how that executive order ended up not being implemented, and conversations started with the company to make sure that there was data security, that there was divestment, and that when those conversations over the next few years ultimately failed, then Congress passed this app. They say, throughout 2021 and 2022, ByteDance negotiated with executive branch officials to develop a national security agreement that would resolve those concerns. Executive branch officials ultimately determined, however, that ByteDance's proposed agreement did not adequately, quote, mitigate the risks posed to U.S. national security interests. They go on to say it was against that backdrop that the act was passed. The ruling goes on to say that the act provides two means by which an application may be designated as a, quote, foreign adversary controlled application. First, the act expressly designates any app operated directly or indirectly by ByteDance Ltd. Or TikTok. So for those that have asked, what about CapCut? When I talked about this on other social media apps, I had said I was not clear what would happen with CapCut, but it's my understanding that CapCut is operated by ByteDance Ltd. So it makes sense that when ByteDance took TikTok offline, because TikTok was specifically noted here, that their interpretation would be that CapCut is designated already in that 270-day period because it is operated by ByteDance and then counts under this act. It goes on to say, second, the app establishes a general designation framework for any application that is both, one, operated by a covered company like ByteDance, that is controlled by a foreign adversary, and two, determined by the president to present a significant threat to the national security of the United States following a public notice and reporting process. In broad terms, the act defines covered company to include a company that operates an application that enables users to generate, share, or view content and has more than 1 million monthly active users. It goes on to say that it carves out an exception for applications whose primary purpose is to allow users to post product reviews, business reviews, or travel information and reviews. It says the Act's prohibitions take effect 270 days after an application is designated as a foreign adversary controlled application. And because the Act itself designates operations by ByteDance and TikTok, prohibitions as to those applications take effect 270 days after the Act's enactment, which is January 19th, 2025. They then go line out what a qualified divestiture means, and a qualified divestiture says the app must no longer be controlled by a foreign adversary, meaning the company that owns the app cannot be subject to the laws that they previously listed out in China. They go on to say the president must further determine that the divestiture, quote, precludes the establishment or maintenance of any operational relationship between the United States operations of the application and any formerly affiliated entities that are controlled by a foreign adversary, including any cooperation with respect to the operation of a content recommending algorithm. So when I've said previously that this act will also target the algorithm and that a divestiture includes not using an algorithm that is connected, well, this is where we're at. With even if it's hosted on other servers, you will not be able to update the app in the App Store if this goes into effect, etc. They go on to say the act permits the president to grant a one-time extension of no more than 90 days with respect to the prohibition's 270-day effective date if the president makes certain certifications to Congress regarding progress towards a qualified divestiture. That is something that we will see perhaps discussed because certifications must be made to Congress. That is specifically not an executive order. What Congress will choose to do with this, we will see. But the act lines out a procedure that includes progress towards a divestiture. What we saw when the attorneys argued before the Supreme Court was the attorneys for TikTok Inc. US saying, no, we have no interest in divesting from our proprietary algorithm. Has that changed? Will that change? We will see. They go on to discuss what level of scrutiny applies. I talked about this as we got into the stream with the Supreme Court. If you are interested, or if you just have law school trauma that you would like to revisit about the differences between strict scrutiny, intermediate scrutiny, and a rational basis test, if you just miss con law desperately, I get it. The court here decided that if they applied strict scrutiny, it would pass, but that they could apply intermediate scrutiny because this act does not implement the First Amendment rights of the company TikTok in the US, because ultimately that company is owned by ByteDance, which is not a US company, and that company does not have First Amendment rights. They also went on to talk about whether this was a content-based restriction and determined that this law is not a content-based restriction because it is neutral as to the content. This law, they say, is tailored to who owns the app and if that company has to cooperate with the laws in China. That is what it goes to. Not what's said on the app, not what content's shared on the app, not what kind of content's on the app, but the ownership. I know not everybody agrees that that's what their purpose is, but that is the stated purpose of the law. And that stated purpose is a valid purpose to meet intermediate scrutiny and strict scrutiny, really, to find that this law is constitutional. The Supreme Court goes on to really state what I just said better, stating, quote, as applied to petitioners, the act satisfies intermediate scrutiny. The challenged provisions further an important government interest unrelated to the suppression of free expression and do not burden substantially more speech than necessary to further that interest. They go on to say the act's prohibitions and divestiture requirement are designed to prevent China, a designated foreign adversary, from leveraging its control over ByteDance to capture the personal data of U.S. TikTok users. This objective qualifies as an important government interest under intermediate scrutiny. Petitioners do not dispute, petitioners being TikTok, do not dispute that the government has an important and well-grounded interest in preventing China from collecting the personal data of tens of millions of United States TikTok users, nor could they. And they make a really important footnote here. You will find in particularly Supreme Court rulings, a lot of important information is in the footnote. In the civil lawsuits I cover, a lot of the shade is in the footnotes. We get those really sassy zinger footnotes in civil litigation. Here they say in their footnote on this page, our holding and analysis are based on the public record without reference to the classified evidence the government filed below. This was something that, well, Justice Gorsuch particularly brought up, but something that was frustrating to see in court is that the government had submitted evidence to the Supreme Court that was essentially classified beyond all of our pay grades, including classified from the defense attorneys. But if you are arguing in court, you can't have a well-functioned adversarial system if both sides don't have the same information. I was glad to see that the court specifically noted that they did not consider the information that was sealed and classified and not given to the defense. There was other sealed information that was proprietary business data that both sides had that the court could consider, but not the information that was given only to the court and not to the other side. And speaking of that, we will look at what Justice Gorsuch has to say about that in his concurrence. They go on to say that the government has explained that ByteDance Ltd. uses the data it collects to train the TikTok recommendation algorithm, which is developed and maintained in China. They say, according to the government, ByteDance Ltd. has previously declined to agree to stop collecting U.S. user data and sending that data to China to train the algorithm. And we saw that in the arguments too. They say the government further noted the difficulties associated with monitoring data shared between ByteDance Ltd. And TikTok Inc. Under these circumstances, we find the government's data collection justification sufficient to sustain the challenged provisions. It's not just about the data, it's about where the data is going. Because what I've seen a lot of questions and whatabouts is, but what about what Facebook collects? What about what all of the Meta properties collect? What about what other social media apps collect? And that's not the question here specifically. It's not the data collection itself. It's the data collection and then where the data goes. That's the heart of what this law is trying to prevent. They conclude with, there is no doubt that for more than 170 million Americans, TikTok offers a distinct and expansive outlet for expression, means of engagement, and source of community. But Congress has determined that divestiture is necessary to address its well-supported national security concerns regarding TikTok's data collection practices and relationship with a foreign adversary. For the foregoing reasons, we conclude that the challenge provisions do not violate petitioners' First Amendment rights, and therefore the judgment of the district court is affirmed, and that judgment found that the law was constitutional, thus finding the law constitutional. Gorsuch, in his concurrence, notes, quote, I am pleased that the court declines to consider the classified evidence the government has submitted to us but shielded from petitioners and their counsel. Efforts to inject secret evidence into judicial proceedings present obvious constitutional concerns. Usually, quote, the evidence used to prove the government's case must be disclosed to the individual so that he has an opportunity to show that it is untrue. Maybe there is a way to handle classified evidence that would afford a similar opportunity in cases like these. Maybe, too, Congress, or even the Standing Committee on Rules and Practice and Procedure, would profit from considering such a question. He goes on to say, but as the court recognizes, we have no business considering the government's secret evidence here. And what I appreciate about Gorsuch is that in this moment, when he says Congress or even the Standing Committee would benefit from addressing this, he's quoting himself in another dissenting opinion from 2022. So it's taking the opportunity to go a step further and say, can y'all please address this? I'm telling you to address, can you listen? People, we can't do this. This isn't how law works. I just picture that scene in Big Hero 6 where Wasabi is saying, society has rules. Gorsuch is saying, court has rules. And secret evidence is not what we're doing. And I appreciate that it was pointed out again. It was brought up during oral arguments. And I think for anyone watching court regularly, that causes concern. Both sides should have the same information as they are going through the adversarial process. Look, the adversarial process is slow, but it is a process. Again, there are rules. And This is why you see discovery. There are timing of when things get exchanged and turned over. There's protections for that. And it's meant to be in the public realm so that the public can see what is happening in the courts. So if the public doesn't like what's happening in the courts, they can tell the lawmakers, hey, can we fix this? And Gorsuch is just reminding, hey, this is an ongoing problem. Can you guys address it? Because we can't address it from the bench. We enforce the laws as they're written by y'all, unless they're not constitutional, and then we tell you to go back and try again. But could you look at this? And we've seen other judges do that too. We saw the judge in the Corey Richins case in Utah saying, I am enforcing the law as it is written today, but I look forward to seeing this law change, indicating the judge said, look, this is a slow process, but down the road, we might see this change. But right now, today, I follow the law as it is today. So what does that mean? Well, I don't know if an executive order is the fix here based on the way that the law is written. I don't know how much Congress will choose to push the issue. I don't know what the conversations are like for the companies that face those substantial fines and how they will choose to navigate this. But for at least today, TikTok is not in the app stores. We don't know where the server support is coming from and what the future of the app will be. But I hope that we will have some clarity around these issues going forward. And I don't think this is the end of the discussion. I also am cautious in whether or not an executive order is the fix here. It might be a short-term stall, but the law is the law. And unless Congress overturns themselves, I don't think this law is going away anytime soon. So we will see what happens from here. Let me know what you were doing on TikTok ban night, because it was a scramble across the internet from what I saw. And speaking of long and drawn out processes, the It Ends With Us movie litigation saga is ongoing. On January 16th, the latest lawsuit in the fleet of lawsuits that had been filed was filed by Wayfarer Studios, Justin Baldoni et al. We're going to go through who the parties are. It is a 179-page filing that dropped while I was streaming. And I was like, we're only going to be able to do the most cursory first looks of this. And since I have had time to read through this and look at the other lawsuits again, because there is clearly very different views of what happened on set. This civil litigation is not going to slow down or be resolved anytime soon. It is on now numerous and multiple fronts, and we have one court date so far. So let's talk about where we are procedurally and then get into what is in this new lawsuit vis-a-vis what is in the other lawsuits. And on this, you're just going to see me looking at my notes a lot because there is a lot going on in all of these lawsuits. So a quick road so far. First, we had the story in the New York Times that is now the basis of numerous lawsuits. The story in the New York Times titled "We Can Bury Anyone Inside a Hollywood Smear Machine" was published on December 21st, 2024. And from there was a flurry of legal filing. That lawsuit attached a complaint that is an administrative complaint. One of the things that is just one of the, I think, undisputed facts is that that complaint, which was administratively filed, would not be public unless it was provided to the New York Times. Who provided it? Well, it would have had to have been one of the parties involved on Lively's side or their lawyers. So that was provided to them. The lawsuits keep referring to it as leaked. I don't think it was leaked. I think it was just provided. Leaked implies that somehow someone didn't want it to be with the New York Times. I don't think it was leaked. I think it was given to them, and maybe I'm parsing words too closely, but the New York Times had it because someone gave it to them who was involved in the drafting of that lawsuit. The next question is there anything wrong with that? Well, no, not legally. You are allowed to provide lawsuits if it's okay with your client. As an attorney, there's nothing that says that you can't unless your client doesn't agree. Then you could have some problems with it. But the story in the New York Times was, they say, an investigative piece. Baldoni's team says was an absolute untrue hit piece that was defamatory. And can you provide things to reporters for them to report on? Yes. Are reporters and outlets largely protected in the things that they do if it can't be proven that it's knowingly false? Yes, which is why you see that it is difficult to sue outlets and easier to sue the people that tell the outlets and determine what they knew to be true or didn't know to be true when they spoke to the outlet. Baldoni's team says that this was all part of really shielding with thinly veiled litigation privilege to say, well, it was in a complaint, so we're protected from defamation for what was provided to the New York Times. But from Baldoni's camp, that is what kicked all of this off. The Lively complaints say that this is not what kicked everything off, that it was, in fact, the PR smear campaign during the promotion of the movie It Ends With Us that kicked all of this off. So, like everything in all of this litigation, there are very different views of the events that follow. And those views are really on the very farthest opposite of what happened here. Some things that I had questions about in the complaint from Lively and in the New York Times defamation complaint are answered in part in the newest filing. Now, do I think the newest filing is overwrought in the way that it's written? Yes, I do. It is written for the public first. Do most lawsuits get filed with 179 pages? No. I mean, the Federal Rules of Civil Procedure really lines out that a complaint should be a, quote, short and plain statement of the grounds for the court's jurisdiction and the claims asserted. Are these a short and plain statement? No. Do they paint a story? Yes. Is that consistent with all of the filings in this fleet of litigation? Yes. Are there things in all of these filings intended, it seems, to support the claims? Yes, but also paint the person submitting the complaint in the best light and the person they are suing in the absolute worst light? Yes. So you will see that doubling down in all of these complaints. And we are at the earliest stages of litigation with all of these complaints. I think what's clear is that there is a very long way to go here, but also because this is a movie set, there will be, I think, a substantial amount of neutral evidence. And what I mean by neutral evidence is we will see things, and we've seen a lot of that in the newest lawsuit. We've seen more emails than were in the New York Times lawsuit, more text messages than were in the New York Times defamation suit. Some of it's the exact same, and some of it's the exact, like paragraph the exact same. But there is more. And what is clear is that there is much more. So again, this is a film set. Things will be presumably on film. And it's mentioned multiple times in the latest filing against Lively and Ryan Reynolds. But there will also be lots and lots of emails. We are dealing with multiple corporations, multiple different attorneys for all of the people involved. And those who are going to get caught in the middle of this are also going to be the best third-party witnesses. Were others on set? What did they see? Because what we are seeing now from all of these suits is kind of similar touch point events or conversations where multiple people are involved in them and two parties having completely opposite retellings of what happened. And that's what's going to be difficult with all of these lawsuits, is because when you get down to it, defamation is going to be based on how somebody perceived a situation. And are they telling the truth to, in this case, the New York Times? Or is what happened and the way they interpreted it not going to meet the level of a, willfully false statement? So when you get into the diametrically opposed interpretations of what happened, the neutral evidence, text messages that happened contemporaneously, emails that were happening at the time on a movie set, film that was happening at the time, and what other people were perceiving in real time, and notes that were taken, conversations that were had and memorialized, that is going to count, I think, for quite a lot. So with that, The one thing that I know for sure is we are a long way from knowing much. And there is quite a lot of information in here, but as much information as in these initial complaints, there's going to be a lot more to come. No one has tipped their whole hand at this point, and no one is going to. This is also going to be a lengthy and clearly messy, scorched earth, everyone's going down with the ship type of a lawsuit, and that has popped off immediately. What I will say is so far, none of the attorneys are taking shots at one another, which we saw pop off exceedingly quickly in the Jay-Z suits. So procedurally, where are we? The New York Times article dropped, then the first filed lawsuit, and keep an asterisk on this one, was the PR lawsuit between Stephanie Jones and Joneswork versus Jennifer Abel, Melissa Nathan, Justin Baldoni, Wayfarer Studios. Why do I say put an asterisk on this one? Well, this filing was provided by TMZ, which doesn't surprise me. TMZ gets tons of litigation before it necessarily hits the public docket. But this is a New York state filing that has the caution this document has not yet been reviewed by the court clerk. And at the bottom of it, it says, this is a copy of a pleading filed electronically pursuant to the rules. At the time of its printout from the court's system, it has not yet been reviewed and approved by the court clerk. Because court rules authorize the clerk to reject filings for various reasons, readers should be aware that documents bearing this legend may not have been accepted for filing by the county clerk. I have not seen this on the court docket yet. It is not anywhere in the publicly available dockets that I can find. It does not yet have an index number. It does not yet have subpoenas attached to it. This is still somewhere in limbo. So that's why I put an asterisk on it, because from December 24th, I would expect by today that this would be accessible. There's no reason it should be sealed. And even if it's sealed, there would be record of the index number. So I have an asterisk on this one. I am going to keep an eye on it, but that is the first one that was filed. However, it is not in the system anywhere. That lawsuit is the one where Joneswork alleges that the other PR agents who left Joneswork with Wayfarer went on a smear campaign against her. We evaluated that together on a live stream and went through the different employment law allegations, plus the interference with contract allegations. I think that the allegations against Baldoni and Wayfarer are harder in that, because when there's a bunch of negativity coming out about a PR agency, is them breaching their contract and leaving going to be a breach of contract at the end of the day? Because when your PR agency is in it, isn't that when we would expect clients to leave? So we will see. But the reason I bring up that Joneswork lawsuit is because it does come up in the latest filing by Wayfarer et al. Against Blake Lively, Ryan Reynolds, and other PR, but not against Joneswork. So there is a whole discussion of what happened with Joneswork that responds directly to this filing, even though Joneswork is not in this lawsuit. I still think what we are going to see in this lawsuit, whenever it hits the docket, is a lot of litigation over whether or not the disclosure of the information from Jennifer Abel's phone was or was not proper. Because Joneswork, and in the filings from Lively, it says that this was all gathered via a subpoena. In the filings by Baldoni, it's saying, no, Joneswork was pissed at Nathan, Abel, Wayfarer, Justin Baldoni, and went and gave it to Lively's team, and it was inappropriate to do so. And that the reason everybody was jumping ship from Joneswork is not because of an orchestrated smear campaign against Jones. It was because of Jones's own actions, which really mirrors what they are saying about Blake Lively. Look, they're saying we did not go on a smear campaign. We had reactive PR because we were afraid of what Lively and Reynolds would do. So we did not go on a smear campaign. You went on a smear campaign. We were trying to protect ourselves. And the reason that there was negative press is because of things that were said, done, and chosen by Lively. So that's what the newest filing is saying. Of course, Lively says in her filings, which was one of the next filings in this saga, Lively is saying, no, this was all retaliation for speaking up about the sexual harassment in the workplace environment, and that this whole smear campaign was based on speaking up on set and was retaliation for that. So we get to New Year's Eve 2024, and the New York Times defamation suit drops, and then the Lively versus Wayfarer, Baldoni, Jamie Heath et al. Drops in New York. So both of those were filed on New Year's Eve. The New York Times defamation suit was filed in the LA Superior Court. The Lively versus Wayfarer et al. Was filed in federal court in the Southern District of New York. And that is the one that includes the claims of sexual harassment under numerous different code sections, retaliation under numerous different code sections, aiding and abetting harassment, breach of contract, intentional infliction of emotional distress, negligent infliction of emotional distress, false light invasion of privacy, which is in both of these suits, and then sexual harassment under the California code, not to the companies, but to specifically Baldoni and Heath. That is a 111-page complaint. It largely echoes what we saw in the complaint attached to the New York Times article and expands on that. The New York Times lawsuit spends a lot of the 87 pages of that lawsuit going over what Lively did and saying that Lively orchestrated all of this to take over the movie, and that these were all exaggerated and fabricated claims, and that those claims were used to not only hijack the movie, but to extort Wayfarer and Baldoni to turn over control of that movie. So we see in the newest filing a lot of what was in the New York Times filing echoed, plus more. And when I said one of these lawsuits has a court date, it's the New York Times suit in the California court. And what did I say about California? I said that this was going to take forever. So yes, there is a court date on calendar. The first case management conference is scheduled for May 1st, 2025. I expect we will see quite aggressive filings from the New York Times in that case to protect them against discovery. We will see how that case progresses. But Wayfarer Studios, Baldoni et al. In this, because it's the same groups of companies and individuals in all of these, currently have the asterisk lawsuit in state court. That is, we will see what happens with Jones' work. I will keep you posted. The New York Times suit is fighting in Los Angeles Superior Court against the New York Times. We know that that's going to be a battle. We know that the New York Times will fight like hell to not turn anything over. And we will see if they make anti-slap motions to try to stop that case from even going to discovery. We'll see what happens. Then we've got the two New York federal cases, Lively suing, Baldoni suing. Both of those have now been assigned to the same judge because they are connected. Yes, they are. Because the two lawsuits are, I reported this, I told you this was going on set, and then you retaliated against me with a negative publicity smear campaign in retaliation for speaking up. And the other side of that being, none of this was authentic and genuine speaking up. All of it was fabricated to extort the production company and those involved with the production of the film to turn over control of the film. And that's what we see in the newest complaint of 179 pages written for public consumption, with all of the storytelling that you would expect from a Bryan Friedman lawsuit. And we've seen this before in Bryan Friedman's lawsuits against Tom Sandoval and Ariana Madix. That lawsuit had some very specific and narrowly tailored claims against Tom and Ariana. But most of the lawsuit threw everyone else under the bus. And so a lot of it was talking about parties that were not being sued and weren't directly related to the suit, but to show that there was this overwhelming environment at Bravo against Rachel Leviss. And so we've seen that style of filing before, and that's exactly what this style of filing is. It is scorched earth. Everyone's going to get dragged, and it is going to be written for media consumption. So what are the key points for me in looking at all of this? Well, now that we have lawsuits that you can kind of line up next to each other, we don't have responses yet. Like there's no replies. And we actually do have a date for replies in the latest Baldoni filing because Blake Lively and Ryan Reynolds agreed to waive service, meaning that somebody for service of process doesn't have to come find you. They agreed to waive service, which means their lawyers can just be served. Yes, you can do that. And with this amount of litigation going on, it doesn't seem like there'd be a reason not to. So their replies are due March 20th. What could that look like? Well, that could be their answers, or that could look like pre-answer litigation, motions to dismiss, and that sort of thing. So we will see. But Lively and Reynolds aren't the only defendants. Let's pull up that document. So this is Wayfarer Studios. These are the plaintiffs. Justin Baldoni, Jamie Heath, It Ends With Us Movie LLC, Melissa Nathan, and Jennifer Abel against Blake Lively, Ryan Reynolds, Leslie Sloan, and Vision PR Inc., the company for Leslie Sloan. This is in federal court. This is the $400 million lawsuit. When we're dealing with movies like this, am I shocked that it's a $400 million lawsuit? No, movies can make a ton of money. If you can't do a sequel, then I can understand the filing numbers. Sometimes you look at filing numbers like that and go, okay, that's just dramatic. But in this one, I actually can see why, given that the first movie made hundreds of millions of dollars. So it is a headline grabbing number, but I also don't think it is wildly outside of the norm as we've seen in some other lawsuits. So what are the causes of action here? I'm going to just relay them to you quickly. Some of these causes of action are under California law. Yes, we may see some litigation over whether or not these California causes of action should be in court in New York. We will just have to wait and see what the lawyers decide to do with that. But we have civil extortion, defamation, false light invasion of privacy, breach of implied covenant of good faith and fair dealing, intentional interference with contractual relations, and with prospective economic advantage in two different types of claims. The civil extortion claims seem to be largely woven into Lively saying, if you don't do this, I won't do this. And Lively and Reynolds saying, and here when I say saying, this is all alleged in this complaint, but the complaint alleges that Lively and Reynolds, through their representation at their talent agency, told Wayfarer and Baldoni that they had to issue a public statement. And if they didn't issue that public statement, then it was going to be gloves off. So it seems that those two things are the heart of the extortion claims, though it is also alleged against Leslie Sloan. We'll see how that all loops in when we get to those motions to dismiss. When we talked about the Lively complaint and the New York Times complaint, some of the questions I had were, what are we going to hear from Sony? We now have some of the emails in here. I said multiple times during all of that coverage that, oh, well, there would probably be an email thread about this and there would probably be an email thread about that. And we've gotten some of those emails in this complaint. We also talked about that 17-point return to work memorandum that ended up being signed as a contract addendum between Wayfarer Studios and Blake Lively saying, I will not return to filming unless these things are met. And we've seen some more context around that from Baldoni's side with an email from Sony saying, we're just as confused as you are about this, where in the email from Lively's lawyers, it says, we have repeatedly been rebuffed in trying to bring this up to you. Lively's side in their complaint says, we have repeatedly brought these issues to a forefront and it has not been addressed and we're not going back to work if it's not addressed. Baldoni's side has said, we were caught off guard by all of this. We had no idea there was a problem. And what are you even talking about? And to support that, they put in an email with Sony executives. So they included the letter that I was just referring to, or the email I was just referring to from Lively's counsel from November 9th, 2023, saying the complaints of our client and others have been repeatedly conveyed and well documented throughout pre-production and photography. They go on to say our client is willing to forego a more formal HR process in favor of everyone returning to work and finishing the film as long as the set is safe moving forward. In order for our client to feel safe returning to production, we're attaching a list of protections, and that's that 17-point memorandum. If production is unwilling to accept or uphold these protections, our client is prepared to pursue her full legal rights and remedies. The complaint alleges that they went back to counsel and said, we don't know because we don't have the email. We have the response email, but went back and said, hey, Can we have a conversation about this? And then they included the email responding to that from Lively's counsel saying, this is not a negotiation. This is what we are asking that need to be in place if we are returning to work. We are not willing to negotiate at this at all. They include an email from November 10th between Sony Business Affairs and Jamie Heath of Wayfarer Studios regarding that email and that 17-point document from Lively's team, and included that conversation with Sony saying, quote, took a look at this following our conversation. No change in my mind from what we discussed last evening. Items 1 through 10, 15, and 17 are basically just yes, of course. Interestingly, I'm surprised that you don't already have a negotiated nudity rider in place given the subject matter and content in the book, or am I misinterpreting her comment? The comment being in that 17 bullet point outlined, but this complaint elsewhere lines out that it was Lively's team that had not gotten that signed and back before photography began. It goes on to say items 1 through 13, I'd want to hear more about what is underlying and what she's hoping to accomplish, respectfully, of course, in the hope that some combination of the studio representation and the empowerment of Alex, presumably, whatever that means, again, hoped for clarification, might mitigate the need to engage an additional A-level producer. Item 14 is a question mark since it sounds like she approved the engaged stunt double, and it does sound like there was a stunt double involved prior to filming. It goes on to say, as for item 16, I guess I'm confused about this as well and why the engagement of day players has found its way onto this list. Perhaps some of the upcoming sensitive scenes involve day players / extras, and this is an attempt to manage the perception of their quote unquote professionalism. Anyway, again, another clarification point. Further, as discussed, overall, the tone of the response has to be part denying the underlying insinuations, allegations, but doing so in a way that doesn't inflame or escalate further, since most of what's on the list, Wayfarers is acknowledging / addressing. And of course, any unease on her part is of paramount concern to the production, and you all are committed to working with her to ensure that she's comfortable with the plan and execution of the next few weeks in order to complete photography, right? And that is the end of that email. But it goes on to say, I'm going to send a copy to folks internally and ask that our production attorney offer any assistance to redacted individuals with respect to the drafting, etc., that they might feel they need best, and then from somebody at Sony Business Affairs. So when I asked during the New York Times lawsuit, where is Sony in this and what are we going to see? We are going to see an extensive discovery process looping in all of those conversations too, because there are things alleged in the New York Times suit that are mirrored in this one that would have had sign-offs at every level. And one of those things was changing the way the marketing materials were printed, removing the a movie by or a film by Justin Baldoni. And those conversations were in here as well. So in this email attached into the complaint from June 18th, 2024, it's an email between Sony executives and Jamie Heath and Wayfarer. It said, hey, Jamie, we had a successful weekend at Book Bonanza. The fans loved the book art displayed at the event. We would like to release this art as our second teaser poster for domestic distribution. Since it has already been released internationally in many markets, it only makes sense to use it domestically as well. We'd love to start printing tomorrow to get it in theaters. However, this version does not have Justin Baldoni's A Film By credit, so we would need to waive that. Please let me know if this is approved. And there are numerous other times in this complaint where they do include the conversations with Sony that were previously detailed or alluded to, but not lined out specifically in the New York Times lawsuit because, well, they don't really belong in the New York Times lawsuit, though alluded to, because some of this is, how does this happen when you have this massive distribution house plus this production studio, as they are saying this film was completely taken over by an actor with a producer credit. They say in this complaint that the producer credit was a producer credit that's commonly given to A-list celebrities, similar to the way we saw Baldwin describe it and Rust saying, I'm a producer, but I don't really have control of everything. Though we do see text messages in here when Lively is asking for dailies. This complaint says that's an inappropriate practice. It's an overstep. It is an attempt to seize control of the project. And you also see text messages from Lively saying, do other producers have access to them? I'll be interested to see what comes out about what that role looked like and what the parties involved thought that producer credit looked like in this film when filming began. Towards the end of this lawsuit, the attorneys line out the heart of this case from their perspective. They say Lively used her power to steal a movie from its director and production studio. Then she held them hostage to her incessant demands by extortionate threat to destroy what they had left. All the while, she failed to understand the heart and soul of the movie she stole and the book it was based on, let alone the intensely personal impact the book had on millions worldwide. When her thoughtless promotions fell flat because they focused on flowery glamour and cross-merchandising opportunities for her own brands rather than on centering the voices of survivors, she finally got a taste of accountability, and she did not care for it. She made one final demand to plaintiffs, that they finally and forever fall on the sword for her by apologizing for things they had not done, killing their future prospects in the process. When they refused, defendants' gloves came off. And this references back to that conversation that I discussed, saying that that seemed to be the heart of where the extortion was, of if you don't do this, then we will do this. They go on to say in the complaint that they use their power and resources to try to take down plaintiffs for good by coordinating with Jones and Sloan, master practitioners of the dark arts of public relations, in an intricately planned character assassination plot. They nearly pulled it off too. So when I say that this is written as a line out for the inevitable series that will be made of these, it is written in that way. But some of the big questions I had asked about where the other pressure was coming from here and how this even happened is lined out, like in this text exchange with Sony executives. The complaint says in April and May 2024, Lively's extortionate threats coerced Sony to allow her to create her own cut of the film, a right that is exclusively reserved for directors, at Wayfarer and Sony's expense. And despite Baldoni and Wayfarer's rightful protest, Sony's reasons for acquiescing to these beyond unreasonable demands were clear. Sony told Wayfarer in no uncertain terms that Lively refused to promote the film unless her demands were met. Wayfarer, feeling increasingly coerced into agreeing to Lively's demands, attempted at least to require that Lively finally sign her engagement contract if her demands were to be met. Even this basic ask was refused, and Sony urged Wayfarer to give in. And then they included screenshots of text messages that look like they are from May 2nd between two Sony executives and Jamie Heath, saying, Jamie, I have redacted name on here too. Redacted name has gotten Blake to approve the trailer we want with our narration, the chair kick, the bruise, etc. And Blake is calling Taylor to approve the song. She, of course, just reached out saying she is asking for time with blank, her editor. We know it was conditional on signing the contract, but asking if you will reconsider. So Redacted can release this trailer, and Blake does not change her mind regarding calling Taylor Swift. Jamie Heath responds, I'm available to talk on the phone. Call me if you're free. Executive 2 says, you guys don't want to play ball. You are going to delay and greatly hurt the movie. Good luck. This is only if you want to make this date. We are going to need to push. Finish director cut, and we can have multiple previews down the road. So when we asked where was Sony all of this, it seems that Sony all of this was also pushing. So how did these things get approved? Because Sony said approve them, it seems, from this filing. Will there be a litany of communications regarding this? Yes. Will Sony executives be thrilled to be pulled into all of these lawsuits? No. But is that what's going to happen as witnesses to this? Absolutely. One of the questions here is, how did all of this happen? It's what I asked repeatedly throughout the New York Times lawsuit. And it seems also with pressure from Sony. What we have not seen in Lively's filings, and I will be interested to see, is discussion of the allegations regarding taking over of the movie. And again, there are going to be paper trails for all of this. And because this is the longest episode ever on this channel, there are a few other points that I found interesting, but when we go through this entire document, we will talk about it. First, the attorneys took time to go through all the different points in that 17-point document. That I don't think was unrelated to the lawsuit or just writing out the drama. I think the direct response to those 17 points in this showed their theory of the case well, because it said, look, these 17 points are all completely misconstrued, which goes to their theory of the case that this was all a coordinated effort to take over the film, that this is not how things went. They are saying, look, Lively says this, that's not how that went down. We're saying this. I also thought the inclusion of the introductory emails between Baldoni and Colleen Hoover, the author of the book that has now become this movie, from 2019 was foundation for their argument that they always wanted to focus on this movie being different. Some of my takeaways from those emails were two things. One is Colleen Hoover's email to Baldoni in 2019 saying, "Thank you so much for the email. I wasn't expecting you to read it so quickly, talking about reading the book. I would love to talk with you more about the project. You get the book. And that's the most important thing to me. My biggest fear is that I'll option it to someone who thinks it's a hot romance and they'll take it in the absolute wrong direction." And seeing all of the fallout from the marketing campaign, my question, though, not as it will go directly to the lawsuit, but then how do we end up with this marketing campaign if it seems that the author said they absolutely did not want it to go that direction, when we've seen the Sony bulletin about focusing away from the sadder, the words in the document, heavier themes of the movie about domestic violence and focusing on the resilience. But it seems that this is something that was much on the author's mind back in 2019. And when Baldoni says that the desire was to focus this movie on those themes, these emails bear that out. They also included an email from April 2019 from the author of the book saying, "Have you given any thought to whether you would want an acting role in this? Say maybe Ryle," which is the male lead in the movie, and the author saying, "I could see it," which also answers some of the questions of the roles of production, directing, acting, and starring, is that the author of the book said, "I can see this." And to that point about the marketing campaign, they did put up a lot of information from Lively's own social medias, but also from the movie's social media. It Ends With Us, the movie, and Sony Pictures, with an Instagram post showing Lively. And the quote from the movie is, "Grab your friends, wear your florals." Now, I don't know if this was posted before Lively ever said this. It had always been my impression from all of these filings that that was something Lively repeatedly said, or if this was something that the It Ends With Us movie Instagram account started and then was continued. I still don't know the answer. However, what we do have is, following that post on Instagram from August 9th, is Wayfarer reaching out to Sony saying, "Hey, what? Grab your friends, wear your florals doesn't seem to be the direction we should be going with the marketing of this movie, even though we've got the Sony doc saying focus on the resilience. Maybe this has gone too far." And they include an email from Sunday, August 11th saying, "Good morning, sharing this post that's using the exact language that has been called out for inappropriately marketing the film." So communications back to Sony, the distributor, saying, what is going on with this marketing plan, and raising those red flags. When you have allegations that this is all planted and all of the negative press is planted, these things are included in this lawsuit to push back on that, saying, no, there were problems here with the marketing of the film, and Lively was getting backlash from it, but it was an organic response to what was being put out there, not just by Lively, but including from the official accounts of the movie, presumably controlled by Sony. And they highlight that by saying that Lively's reputational backlash was entirely of her own doing. And to kind of put a point on the how does this happen, from this complaint, they included a text message from, it looks like, April 2023, in a threaded conversation between Lively and Baldoni, talking about the film, talking about rewriting, talking about the excitement of Ryan Reynolds and Taylor, presumably Swift, and how excited they were about supporting Lively in her creative expression and in rewriting scenes, which is discussed much in this lawsuit. but it includes a text saying for redacted, though I don't know if they meant to redact it in all of the text. They don't. Talking about that rooftop scene for redacted and Ryan, and for redacted for that matter. I'm the luckiest motherfucker on the planet to have them as my dance moms, level stage moms. They are embarrassingly effusive. That said, they are also my most trusted partners and the people I go to first with anything creative I touch. And I'm the person they each go to first. That reciprocal creativity and support has been one of my life's greatest and most fulfilling gifts. When they loved and signed off on the pages, I felt good to send them to you. They asked what you thought specifically after. They checked in so many times. I told them that you laughed a bunch and said it's probably a blend, but you appreciate my passion so much, which of course didn't feel great to me or them to have my passion be praised instead of any specific contribution, or even just that you didn't like the pages, which was also fine. So I think they wanted you and me to see how they felt about the work, because they've been by my side for far too many experiences where I've been overlooked. I spoke to you about this when we first met. They've watched me handwrite scripts because the director is too afraid to send the FDX file, yet he scans and has someone hand type all 120 pages of my pencil rewrites. They've watched me be hired as a writer and paid a significant fee for it, but on the condition that I never ask for credit, which I could give a shit about. It's more the principle and the dynamics at play. They've watched the other side of it too, where I'm told at signing on that I'm wanted as a true collaborator, but once we get to work, I'm really just wanted as a yes man, audience, and actor. They say both Ryan and Redacted have established themselves as absolute titans, writers, and storytellers outside of their primary gig, just singing or just acting or blank just directing. I'm so lucky to have them as creative barometers, but also to have them as the people who prop me up and make sure I am seen for all I can and do offer. It goes on to say, and this cuts pages, but I imagine because all the phones are redacted, we will see if this flows smoothly down the road. But it cuts pages and goes on to say, if you ever get around to watching Game of Thrones, you'll appreciate that I'm Khaleesi, and like her, I happen to have a few dragons, for better or worse, but usually better, because my dragons also protect those I fight for. So really, we all benefit from those gorgeous monsters of mine's, laughing face emoji. You will too, I can promise you. They go on to say in this complaint that that was taken as the beginning of the wielding of power and influence, that if you don't acquiesce to the demands, then it's not just me that you are coming for, it is me and those in power around me who are my dragons. I think there will also be arguments when we see the reply from the other side that we will see a line out of what the producer title meant in this film, because in some of this text, it also seems that there is a concern about being sidelined and saying, I signed on to this project as a producer. I don't want to be sidelined as a producer, where you're seeing the other side arguing, no, that producer credit is really a name only producer credit. And all of these things that were being done, including wardrobe and bringing in editors and editing a cut of the movie, that was all way outside the boundaries of what was considered appropriate and was the reason behind the complaints on set that do not align with what happened on set. So where does that leave us with this case? Well, it's going to leave us with a mess of litigation over really what happened on the set of this movie and what all the contemporaneous emails, text messages, and back and forth, I think, behind the scenes say. Because as this relationship deteriorates from collaborators to Lively saying that she felt uncomfortable and harassed on set, and Baldoni and Wayfarer saying they felt extorted and that their project was robbed from them, I imagine what we will see is a lot more emails behind the scenes of everyone else that's involved talking about how to resolve this problem. And if the paper trail is there, we will see it. If a paper trail is not there, we will see that too. But is this going to play out in trial anytime soon? No. Do I think the main venue for this will all be in federal court in New York? Yes. Is that televised? No, it's not. So What I think we'll see is a lot more lengthy filings, with both sides continuing to double down and continuing to include all of the information. The lawyers for Wayfair and Baldoni really threw down a gauntlet in this particular filing saying, we want to go to full discovery and we want the court and the public to see everything. So it puts the defendants in this case in a position where if they are not as transparent, it is going to be difficult for them, because if one side is saying we want the public to see everything and the other side saying we don't want the public to see anything, that's not going to go well. So we will see what happens in the replies. I will be breaking this down more because I did not have time to go over it all on Thursday when it dropped, but there were definitely some interesting parts of this lawsuit that go beyond some of the cherry-picked text messages we saw in some of the other lawsuits. So this one is far from over, and we will see what all of the litigation shows from here. I think this lawsuit will probably get pared down with some of the causes of action because it doesn't seem that they all go to every defendant, but we'll see. And there's going to be lots of fighting over discovery. So this one's going to take quite a while. And with that, this has been an extended episode because there was lots to discuss. Thank you for being here. Thank you for being a law nerd, and may the odds be ever in your favor. I will see you on live stream this week. Don't forget to get the Law Nerd app to stay in the loop with everything I'm covering. Talk to you soon. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a law nerd.